Hello, everyone, and welcome to the Improving Case for Joint Ventures in the Middle East. My name is Charles Halab. Bear with me for a moment. I've got a little bit of a script here, and then we'll get to the meat of the presentation. Thank you for joining Mayer Brown's Joint Venture and Strategic Alliance practice for our informational webinar series. The goal of our practice is to help our clients establish and grow successful joint ventures and strategic alliances, from the early planning and strategy stages to formation and operation, as well as disputes and exits. Our presentation today will focus on trends relating to formation of joint ventures in the Middle East, specifically in Saudi Arabia and the UAE. In addition to today's presentation, we will be conducting future presentations covering a range of topics on joint ventures and strategic alliances, and invite you to join us for those upcoming events as well. You can find information on our practice, as well as past programs, at our website, mayerbrown.com. Our goal is to provide practical and strategic advice to help you establish and grow successful joint ventures and strategic alliances across the globe. A couple of brief administrative matters and introductions, and then we'll get started. This webinar is being recorded. In a day or so, we'll be sending you a link which you can use to listen to the presentation or share with your colleagues and friends. Also, for those obtaining CLE credit for this program, we will announce the event code in the middle and again at the end of this program. If you do have a question, please type it out in the chat section of the WebEx login. We will try to answer questions at the end of the presentation, time permitting, or otherwise follow up with you after the presentation if time expires. My name is Charles Halab. I'm delighted to participate with my partner, Tom Freya, on today's call. I'm a partner in Mayer Brown's Washington, D.C. office, as well as its Dubai office. And I am one of the leaders of our firm's joint venture and strategic alliance practice. I'm also chair of the Middle East practice. Joining me today is Tom Freya. Tom is the partner in charge of Mayer Brown's Dubai office, head of the firm's Middle East corporate and commercial team. Tom has spent over a decade practicing in the UAE and the Middle East region. With that brief introduction, I think we're ready to kick it off. I'm going to start today's presentation with an overview of some of the changes and observations we have about Saudi Arabia. We've chosen to focus on Saudi Arabia and the UAE not by coincidence. It's because that's where the heavy focus of our practice is, and the focus is there because that's where our clients take us more often than not. So they seem to be the two jurisdictions of greatest importance and relevance to the many multinational clients that we serve and assist. In the Kingdom of Saudi Arabia, there have been two areas of development as of late, at least the way we're thinking about it. The first is those that can be categorized as legal developments. The second, just for ease of discussion, we're describing as non-legal. And in each of those two areas, we found, with some amount of subjectivity, admittedly, but hopefully a fair degree of objectivity as well, that things have really improved in recent years for those seeking to do business with or in the kingdom, and in particular in the area of joint ventures. So just a quick overview of some of the legal developments. As many of you know, in 2015, Saudi Arabia introduced a new companies law that really implemented wide-ranging reforms across the regulations, some of which are particularly interesting and helpful to clients of ours, as I said, multinationals, thinking or seeking to do business in Saudi Arabia. Those include limited liability companies, which are the typical form that joint ventures take, can now be formed with a single member. That has implications, a number of implications, a couple of which I'll mention. Deadlock, for sure, when it comes to resolving disputes. In various deadlock scenarios, as many of you know, you'll have to have one partner buy out the other. That was a bit tricky before when single-member LLCs were not permitted, now less so. It also makes it easier to form joint ventures above the Saudi Arabian entity. So to establish an LLC in Saudi Arabia and form a joint venture elsewhere that holds the joint venture entity as a wholly owned entity within Saudi Arabia. Another implication is that members in LLCs are no longer jointly liable for the debts of the LLC itself. That's important to many of our clients who fear bad acting on the part of the joint venture partners. In addition to the company's law, there are relaxed local ownership and capital requirements, and some of those are embedded within the new company's law. Now, non-Saudi investors in the kingdom have the flexibility to structure their company more effectively to benefit from the opportunities in the Saudi market, in particular by seeking 100% ownership in the joint venture, by seeking 100% ownership in the limited liability company, or by forming a joint venture at a percentage that makes business sense for them. This is a dramatic improvement over years past and over other jurisdictions where local ownership was a requirement and is a requirement. Also, much to the delight of some, the capital requirements have been relaxed in recent years, making it less onerous from a financial perspective to set up limited liability companies in the kingdom. There's still some significant capital requirements for those seeking to establish a manufacturing facility in the industrial sector, but as we'll touch on later, many of those are offset by financial incentives, subsidies, access to loans, interest-free loans, and the like. Perhaps most noticeable for many of our clients is the dramatic improvement in efficiency in government services as of late. Any company seeking to invest in the kingdom or do business in the kingdom has had in the past to go through the Saudi Arabian General Investment Authority and the Ministry of Commerce. As part of the overall reforms, those two entities were merged, which may not seem like a lot to those participating in today's call, but trust me, from a practitioner who works in Saudi Arabia week in and week out, that has made a tremendous difference, both for us and for our clients, in streamlining access to the bureaucracy there, streamlining the bureaucracy, eliminating bureaucracy, and getting our clients set up in a much more practical timeline. From what used to take months and months and sometimes more months, now down to 30 days or less even to get an investment license. That has opened up opportunities for companies who are responding to RFPs, to government opportunities where they need to think and act quickly. So the fact that those Saudi Arabia General Investment Authority and the Ministry of Commerce are now essentially a one-stop shop for investment approval and assistance has had a notable impact on our clients. Tax incentives, well, Saudi Arabia has always been fairly attractive from a tax perspective. Some notable aspects and or developments are the 20% tax rate on corporate profit, but the ability to carry forward losses, the full repatriation of capital, profit, and dividends, subject to a small withholding tax, the earnings exemption, earnings from exports are tax exempt, and perhaps important to many of those on the phone, companies making R&D investments in the kingdom are eligible for some very serious and lucrative tax credits. Other aspects, legal in particular, of Saudi Arabia's joint venture landscape. Saudi Arabia has recently relaxed its restrictions on real estate investment in the kingdom for non-Saudis. That's fairly revolutionary, something we wouldn't have expected when Tom and I began practicing there years and perhaps now decades ago. Obviously makes it more attractive for companies who are who need to own real estate as part of their overall value proposition. Licensed companies, non-Saudi companies can serve as immigration sponsors now for their investors and for their non-Saudi employees, whereas previously a local partner and a local sponsor was required. That's another one of those things that may seem innocuous, but has been a dramatic improvement. I can't tell you how much time our team, both here and there on the ground in Saudi Arabia and the UAE and other jurisdictions, spends trying to resolve immigration issues. This was a huge step forward for Saudi Arabia. Other things, such as manufacturing requirements, this is more in the vein of a stick than a carrot, but nonetheless, there are new local manufacturing requirements. For example, the one that requires Saudi's military equipment to be manufactured locally. Obviously, a heavy incentive to set up locally. But those are married with, as I alluded to before, a whole host of incentives to do so. And then finally, without going into a nauseating detail on it, one of the issues that has plagued companies in the past seeking to do business in Saudi Arabia, seeking to partner in Saudi Arabia, and in particular seeking to joint venture in Saudi Arabia is, you know, how easy it is or not to get out when it's time to get out. And both from a regulatory perspective and from a general doing business cultural perspective, that has gotten significantly easier in recent years. On the non-legal front, if you recall, I was talking about sort of two general categories. Many of you have heard of the Saudi 2030 vision, Vision 2030, sometimes it's referred to, and this is the one that's touted by the new Crown Prince and heavily endorsed by those who are leading Saudi Arabia now into the future. It aims to spur economic diversity and sustainability with the goal of reducing reliance on oil for the kingdom. There's so many aspects to Vision 2030 that are worth talking about and exciting to talk about, at least for nerds like us. But I think the ones that are perhaps most relevant to today's discussion are the funds and the mechanisms that 2030 has imagined to assist, in particular, companies coming in to partner and to establish in Saudi Arabia. Very quickly, those are the Human Resources Development Fund, which provides investors with tools and guidance to qualify, train, and recruit Saudi workers. That is a top priority for the government, for the ruling family, and companies are well served, those seeking to do business in Saudi Arabia, to have a plan to recruit, hire, train Saudi workers, and the government will work hand in hand with you in that regard. The Saudi Industrial Development Fund, which helps provide financing, has made loans much more easy to obtain, and depending on the project in question, those loans can be extremely low or zero interest. MODON, or the Saudi Industrial Property Authority, has responsibility for developing the industrial cities in the kingdom, with a focus, of course, on increasing, enhancing Saudi's manufacturing base. There's some statistics here about what's happening. 34 cities in the kingdom, more than 5,800 factories at last count, and more, probably about 500,000 employees, and increasing every day. So again, I don't need to get into the detail. All of this is easily accessible, and we're happy to provide information to anyone who's interested in the detail. But the gist of it is that they are very serious about this effort, about diversifying, about creating a sustainable economy that's not entirely reliant on oil. And they see, as part of that effort, a need to attract partners, investors from around the world. And this is probably, anecdotally, the best time that we've ever experienced as legal practitioners in representing multinationals going into the kingdom and the region more broadly, because their willingness to put their money where their mouth is and their mouth where their money is in making investments, partnerships, ventures attractive is better than it's ever been. Thank you. And Tom?
Great. Thanks, Charles. So obviously my portion of the discussion is going to be focused on the UAE. And much like Saudi Arabia, the UAE introduced an amendment to the companies law in 2015. I will say, unfortunately, it's probably not as positive in terms of its results as the Saudi amendments. And a part of that is because the baseline changes were already quite attractive in the UAE. But I will say there's the new companies law, the amendment to 2015, has probably been viewed as a little bit disappointing to many. And maybe I'll just mention one reason that's not in the slides is because many of you may know the UAE has roughly around 38 free zones. And these free zones are essentially jurisdictions, if you like, a Vatican within Rome kind of concept, where multinationals can own 100% of a local entity. Unlike onshore, you have to have a local shareholder who owns 51%. And so the idea was, or the anticipation was, that this new amendment law was going to come in and say it's going to effectively do what Saudi did, which is allow for 100% foreign ownership and maybe potentially have a negative list of certain sectors, and only those certain sectors require a local shareholder who owns 51%. Unfortunately, that didn't happen, and so for that reason, there's been a little bit of sort of disappointing sentiment that came out of the amendment. Now, that said, I wanted to sort of go into some of the sort of positive trends that we're seeing. I mean, despite the fact that the law didn't sort of go as far as everyone wanted, there is definitely a healthy uptick in terms of joint venture formations and even sort of corporate conversions into joint venture entities in the UAE, and there's a bit of a reason for that. And so we've highlighted 5 points, and these 5 points, in reality, could have been the same discussion that could have been the same list, let's say, 2 or 3 years ago, even before the amendments came out. But with the amendment itself, it sort of spurred on some additional discussion that likely resulted in sort of the healthy uptick that we've seen. So the first one is it's sort of a natural progression of business from purely commercial agency arrangements to a joint venture. This won't be that significant for those of you on the line who have marketing entities that are based in the UAE that are really there to try to sort of use it as a hub for the region, right? You're likely going to be in a free zone, no need to have an onshore LLC, because you're not really, if you like, doing business in the UAE. You're essentially using the free zone as a platform for a marketing effort throughout the region. However, for those companies that are in the UAE and actually doing business in the UAE, you would probably see this, that there's so much competition there. There's obviously multinationals from across the world in various sectors that have realized that the natural progression from a sort of a commercial agency or relying on a local sponsor only goes a certain way before you have to then really have your own legal entity on the ground and have more control over it. And that really has a lot to do with direct client interface. Clients are becoming more demanding. They don't like to rely on sort of a middleman, if you like. They'd like to have real engineers on the ground that are working for the company that's providing the services. Better brand recognition, certainly, and then direct employee sponsorships. Unlike Saudi Arabia, the sponsorship rules are still pretty restrictive from that perspective, and so having your own legal entity in control of that sponsorship is pretty key. The second one is avoiding significant pitfalls in a registered commercial agency. I think if you sort of look at the typical sort of lifeline of business FDI into the UAE, you'll have oftentimes a company, multinational, that tries to find a local sponsor or local agent to provide a platform for its services, and then over time, there's a sort of a realization that more is needed, so you might set up a marketing entity where you have your own individuals there, and then over time it turns into a full-fledged trading entity, which is the form of a joint venture. And part of that realization, if you like, or part of the graduating from one phase to the next, is that if you rely just on a commercial agent who happens to be registered with the Ministry of Economy, it is the most restrictive commercial agency regulations in the world is in the UAE. They're only tied, I think, for two other countries in the world. And what that means is if you ever wanted to terminate your registered agent, you have to get the consent of the agent that's being terminated, which essentially turns into a complete veto right. And so from that risk analysis alone, companies try to skip that process and say, look, I'd rather deal with a local shareholder than a complete handcuffing of a commercial agency law. And so for that reason, again, it becomes a really important issue that many of our clients in their management level discussions certainly take in consideration. The third one there is consolidation of accounts. This is obviously depending on what sector and what clients we're dealing with, but oftentimes when there's significant investment going in and you're unable to consolidate from an accounting perspective, that could be an impetus alone to set up a local joint venture trading entity. Number four, a show of greater local investment. This is true for the same reasons that Charles was mentioning sort of from the Saudi perspective. I mean, depending on what services you're in and who your ultimate clients are, if your clients are governments, government entities, and you're responding to procurement proposals, having a longevity of an onshore presence is certainly a huge benefit. And if you simply rely on sort of a commercial agency in those proposals, oftentimes you will actually see in the RFP itself, it'll say we have a preference, or we will make, part of the considerations is a preference for companies that are truly invested, and what they mean by that is obviously a local LLC entity. So that shouldn't be something that's overlooked. I will say if you're providing services, purely services, you could do it certainly through a branch entity, so that doesn't exclude you completely, but oftentimes government RFPs don't make that distinction. And the last one there is greater management control and greater, I would say, sort of provable claims to profits. So if you think back, if you have a branch entity, obviously not a concern, but if you have a commercial agency, then having management control of a commercial agent, third-party commercial agents, obviously can be challenging at times. And then how the profits are distributed, or how the profits are even accounted, or even frankly oversight and auditing rights for the business operations from a financial perspective, oftentimes is a key consideration for wanting to set up a local LLC entity. So on the next set of slides, and again, this isn't really sort of trying to compare what the law was before the amendment and what the law is after. It's not simply just that. It's trying to also capture some of the recent discussions on the legal sort of environment that is tied into the amendment. So you'll see some of that in this. And so the first one is obviously the prior position, which is still the current position to a greater extent, is the 51% local ownership rule. This is always going to be the issue that our clients face when making this decision. You can imagine how difficult it is when you tell them you must have a local shareholder who owns 51% of your shares, even though you don't need that shareholder, even though that shareholder may have absolutely no impact, positive or negative, to the business. It's just the cost of doing business. And so that's obviously a very difficult threshold to get over psychologically, let alone from a contractual legal perspective. And the second point that is tied into that, obviously, is a difficulty in guaranteeing that the local shareholder will honor its terms. And so oftentimes, which we'll get into in a second, you'll try to ring fence the exercise of the local shareholder's powers through various agreements and various structures and arrangements, but at the end of the day, there's no guarantee that the local shareholder will honor those terms. And we've definitely had our share of nightmare stories with regards to that. So if you look at sort of the current positions, or what the amendment has sort of highlighted, if you like, or reinforced, and maybe even some of the developments within the market, is obviously the free zone options are always there. They've in a sense become more reliant. I will say that there's even within a certain cluster of free zones, there's some discussions between those free zones and the onshore regulatory body to see whether or not the free zones can operate onshore. For example, if you've seen recent press releases, the DIFC, the Dubai International Financial Center free zone, which is the sort of the crown jewel, if you like, among the free zones in Dubai, effectively has allowed companies that are registered in the free zone to actually do business onshore, depending on what sectors you're in, and certain terms and qualifications apply to that. So we're hopefully seeing that there's, the fact that the amendment didn't completely get rid of the 51% local ownership rule actually makes the free zones become a lot more important, and there appears to be a movement towards taking the free zones and allowing them to operate onshore to some degree. So hopefully in the next iteration of amendment, that will become even more positive. The second point there is definitely one not to be overlooked. It's actually a really big deal, and it's if you can imagine that the local shareholder who owns 51% of your shares before couldn't pledge the shares. You would have sort of loose voting agreements to sort of try to, again, handcuff the local shareholders' abilities to exercise the rights under those shares. But there was nothing formal that you can actually do. It was all sort of contractual. Lawyers would sort of come up with clever ideas and agreements. The courts never really opined on those. In fact, in some cases, did the opposite. So you're kind of stuck in this very strange situation where you're not actually sure that what you're drafting and what you're signing is actually going to be enforceable. The fact that we now have pledging of shares is a very good step forward. It's very good. It's obviously the lobbying for this came from creditors, not so much from foreign multinational shareholders, minority shareholders, but certainly it can be applied to both. So if you're a foreign multinational giving a loan to a shareholder, for example, for paying off the share capital, well, that loan could be pledged against the shares, which is a good way to ensure that the local shareholder doesn't do anything apart from what's included in the shareholder agreement. Jumping to the second point, which sort of dovetails off the first one, is nominee shareholder arrangements. So obviously, you're stuck with the 51% local shareholder. You enter into a shareholder agreement or a trustor agreement or a nominee agreement. And the prior position, if you like, or the reality that we sort of have to deal with always is that there's no legal recognition of trust agreements in the UAE, apart from the DIFC, which we'll get into. That's an English law jurisdiction. But the UAE itself has no recognition at all of trust agreements. In fact, there's been some cases in Abu Dhabi that have completely rejected trust agreements. And then nominee agreements, generally speaking, and you can probably sort of scour the law firms within the UAE to get different opinions, but the general consensus is that they're untested and viewed as likely unenforceable. May not necessarily be a positive or negative statement, but nevertheless, it's not a very comforting one for our clients. Now, and this is not really just because of the 2015 amendments, but the introduction of corporate nominee shareholder companies has dramatically changed the landscape. So before, you have to literally go out and find an Emirati who's got a passport and a pulse to act as your shareholder. Now you can actually go to a corporate nominee shareholding company that does this for a living, if you like. And these companies have MOUs or memorandum of understandings with the governing bodies onshore, so with the Ministry of Economy and with the Department of Economic Development. And these companies effectively serve as corporate nominees, as you would imagine, in other jurisdictions. So they're going to abide by the contract. They're not going. You don't have the sort of local shareholder risk, if you like. Certainly, there's a cost to it, but it's a financial cost. And so at least you have certainty that what you're entering into, this party is going to abide by it, because that's the whole business proposition. So you've got about 6 or 7 companies now in the UAE that do this, and each one of them roughly has, some of the bigger ones have about 500 or 600 companies of which they act as a local shareholder for. So that's definitely changed the landscape. In the 2015 amendments, there was some concern that they were going to address this issue, meaning in a negative sense, but they've been silent on it, which is a positive reinforcement. Very quickly, the DIFC, which is an English law jurisdiction within the UAE, which is a strange concept, but if you can imagine, the UAE is a civil jurisdiction, and within it, there's a free zone called the DIFC that has English law. And so you can actually do a trust arrangement there. So you can have a company that sits above the local onshore LLC that has a trust arrangement in place. Various different ways to do this, some very complex, some of them probably overly complex, but the reality is at least you have some trust characteristics that you would expect in other jurisdictions. The third one, and again, I think this one sort of overlooked by a lot of our clients is initially, is the power. You can impose a power of attorney or have the local shareholder grant you a power of attorney that would allow you to unilaterally transfer your shares, or the local shareholder's shares, to another shareholder. And so that eliminates this concern of needing to take the local shareholder by the hand to the notary public and convince them to transfer their shares. It's a very difficult thing to do. But if you have a power of attorney in advance that they issue to you, obviously that eliminates that step. The one cautionary point there is that these powers of attorney attorneys are generally only valid for 2 to 3 years. So a notary will only allow you to do that if it's still it hasn't gone stale. And the last one there, which could be a discussion in and of itself, but just the arrangements that are removing sort of Islamic law, Sharia inheritance risks. So if you have a local shareholder who's a shareholder by individually, and that individual has 5 or 10 children, and if he were to pass on, then you would essentially inherit all those shareholders with different competing issues and so on. So there's different ways to sort of structure around that to effectively give you an automatic sell trigger to avoid such issues. Moving on to the management control. Again, previously, if you sort of look at some of the sort of older joint venture arrangements in the UAE, I think oftentimes multinational clients sort of assume that it's best to make sure that the local partner has absolutely no involvement at all with the management of the local entity. And while that sounds like a great idea at the beginning, we certainly never sort of advise to do that. And the reason is, if the local partner becomes completely silent, then that local partner can actually, if there's a dispute or if there's a liability against the company or if there's issues that come before the court, the local partner can essentially say there's a valid reason for a piercing of the corporate veil. In other words, the multinational minority shareholder has effectively been running this company on their own. Therefore, there should be unlimited liability with regards to those management actions by the foreign shareholder, and the local shareholder should be completely immune from that. And there's been some cases with regards to that. So for that reason, we say, look, obviously for the key decision making and the sort of material decisions, those of course should be done by the multinational, but you should not exclude the local shareholder. So make sure they attend the annual meetings, make sure they have some sort of visibility in terms of what's been decided and what's happening at the company level. And with regards to what the current amendments have allowed for, the nice thing is they've taken away the cap in terms of how many directors you can have, so that gives you more flexibility. You can have directors that don't have to be sitting in the UAE, but you can load up the board certainly in your favor. And there's a recognition that there's a greater need for management control by the foreign shareholder. That was essentially not really an issue that was addressed. It was just assumed 51% means 51% real ownership in the prior version of the law, and now there's obviously a recognition that 51% may be a nominee arrangement as a result that requires the foreign shareholder to have more management control. Just a real quick minor point on the second bullet there is that one thing to keep in mind is that you want to avoid, depending on what sector you're in, depending on how much risk there is in the practice in the business itself, having your general manager, which is a really important position locally, having that general manager always appointed by the foreign shareholder, you have to understand that that individual can be detained, can be brought into questioning, can be put under house arrest in the UAE, because that's the only individual from a local perspective that's the face of the company. And so for that reason, the authorities put a significant amount of attention on that. So oftentimes what we recommend is if the business risk is pretty high, then what we would suggest is having the local shareholder be the general manager with very limited powers, and behind the scenes having a sort of a CEO, if you like, that's appointed by the foreign shareholder, has essentially all the real powers. And if there's any issues that come about, then at least you don't have someone being detained, you don't have someone sort of being questioned. And frankly, it's much better for the local shareholder who can speak Arabic, who can converse with the authorities in a much better way than likely a general manager that's appointed by the foreign shareholder. The last 2 points, I'll quickly go over them. Sort of as Charles mentioned, the difficulty is always in the discussion about joint ventures is how do we get out when we need to get out. And the reality is, before the amendments, it's all about negotiation. You can't really dissolve, you can't really wind up a company unless you have mutual agreement by the shareholders. And there's no real effective injunctive relief in the UAE, so you can't sort of cause it to happen. So you end up having this long, protracted negotiations, usually about price, usually about sort of what happens post liquidation. And this is usually a very frustrating aspect for clients, usually something that surprises them on the tail end. Now, under the new amendments, it doesn't necessarily, it's the same sort of preemptive rights exist, unfortunately. The scheme hasn't been changed, and this is one of the disappointing aspects. However, because the disputes are normally around price, they've put a mechanism that one party can effectively go to the Chamber of Commerce and say, look, we're trying to dissolve the entity, we're trying to wind it up, we're not agreeing upon price, and the Chamber of Commerce will in fact appoint a financial expert who has the authority and the powers to determine the price. So that may be a good or bad thing depending on how the outcome of that is. Some of these experts aren't truly experts in every single kind of valuation of companies, but nevertheless, at least there's a mechanism in place, and oftentimes you end up using that almost as leverage, let alone going through the process. So that's certainly a positive point, maybe not quite as positive as we were hoping, but certainly one that's going in the right direction. And then finally, the enforcement of shareholder rights. And again, we've sort of talked about this already, but nominee agreements, shareholder agreements, side agreements, whatever you may call them, there's sort of limited enforcement in the UAE, not so much because they have an aversion against these agreements, but because some of the provisions in those agreements aren't necessarily ones that you can find in the company's law or even in the transaction law. So if it's a call or put option or if it's a deadlock option, these have to be then sort of localized in terms of how they're going to be enforced and or executed. And so there's always a gap in that perspective. Now, the new amendments in the law have not addressed that at all. However, the trend has always been, in the last 2 or 3 years, the reliance more on the DIFC, right? So this is the English law jurisdiction, has its own courts. Those are English law judges. And now, specifically within the Emirate of Dubai, a judgment from a DIFC court with some sort of procedures can actually now become a judgment of a UAE court. It just has to be sort of ratified, if you like. And so multinationals are certainly caught onto this and making their agreements English law governed and enforced by the DIFC courts. So at least issues like call and put options and deadlock options, at least theoretically, are obviously not ones that are going to have as a limited enforcement cloud above them as you would normally find. So those are the points that just wanted to mention. Again, some of these are not necessarily because of the amendment in 2015, but the amendment in 2015 either staying silent or addressing some of these have certainly made these legal developments, at least in the environment in the UAE. So with that, I think I'll pass it over to you, Charles.
I think that wraps it up for us. We're a little early. I don't see any questions that have come through, so we'll give everyone a gift and let them go just a couple minutes early here. Thank you very much for joining us today. For those seeking to obtain CLE credit, the code again is 07MEMB26. Please complete the form you were sent with your invitation and return it to CLE-events@mayorbrown.com. Again, that's CLE-events@mayorbrown.com. We'll be sending...
Charles, I'm sorry, this is Bill in Chicago. There are a couple of questions.
Oh, there are?
Yeah. I can read them to you. Let me see. They appeared.
Oh, yes.
If you click on the Q&A section, I'm sorry. One is stated, at what point is there an advantage for a branch office in the UAE healthcare city free zone to consider establishing a JV presence?
Yeah, very good question. In fact, most of our global pharma and healthcare clients almost all have branch entities or even LLC entities in the Dubai Healthcare City, which obviously would be 100% owned by them. Where it becomes, I would almost say, critical for them to form an onshore entity is, so if they're providing services to the health department or the Ministry of Health at the federal level, and those services require them to not simply just provide the services from within the free zone, but actually go out and provide services onshore. So visiting the hospitals, doing some operations, and I don't mean sort of medical operations, but providing the services on site. That is when you either have to rely upon a service provider to do that, or you have to form a local onshore LLC. And in fact, in some of the RFPs, you'll see the Department of Health or the Ministry of Health, depending on the emirate level or federal level, will actually state that you need to have a trading license, a DED-approved trading license, which by definition a free zone company cannot do or would not be able to do. Now, having said that, many companies provide the services from the free zone, and so long as a client has no issue, then there's, if you like, everyone sort of blinks an eye. I mean, there's no real impediment. But as these RFPs become more and more competitive, there definitely is a push under the procurement law to certainly favor companies that have the proper trade license. So it really just depends on the opportunities that are provided. So if it's just services that can be done from within the free zone, and that's a very important word, from within the free zone, then certainly no need to have anything apart from the branch. But if it's services that require onshore servicing, and that's a significant portion of what in fact is being performed, then yes, you would have to do either an LLC onshore or sign up a local agent who has authority to provide those services onshore.
Okay, thanks. There's another question. I think this one's probably for Charles. Can you discuss the new energy industry city developments in Saudi Arabia?
Candidly, I can't. I don't have all the specifics at the moment, but for whomever asked the question, we're happy to follow up with you with a number of those specifics.
And this is from the same questioner. Any special advice for a small company seeking a partnership in Saudi Arabia?
Yeah, well, all sorts of advice, and we're happy to chat with that person or those persons off the clock to give them our thoughts at greater length. But my best advice is get smart on what incentives the Saudis are offering. Make sure that you are in a position to avail yourselves of those incentives. Talk to the U.S.-Saudi Business Council, which is a tremendous organization in terms of bilateral business investment between the United States and Saudi Arabia. To talk to us or any other lawyers of your choosing that you believe are trustworthy, because there are some legal pitfalls. But in all objectivity, I think this is a great time to be exploring the opportunity. And I wouldn't have always said that over the course of my career.
Okay, very good. That's all the questions that have been submitted.
We will be sending out a link to today's presentation, and if you have additional questions, obviously, we encourage you to submit them to me or to Tom. Thank you very much for participating, and be on the lookout for future invitations to other programs from our joint ventures and strategic alliances practice. Thank you, everyone.